Hello, Sandra Fuentez with Fuentez Law. If you can't make up, we'll help you break up. Let's talk today about what happens to the house in a divorce case. So, oftentimes with a community property house, that means a house that a party has purchased during the marriage. It doesn't matter if the house is not in your name, if it's just in your spouse's name, or if only your spouse has been paying towards it. So long as it was something that was purchased by one of the spouses after the marriage and that we still have the house and now we're filing for divorce, that house is community property and subject to an equitable division or 50-50 division on the equity of that home. So if there is one spouse who is trying to keep the house, then they have to have substantial assets between the both of them. Well, really the spouse who's trying to keep it has to have an asset under their name that's significant enough to award to the other spouse as that other spouse's buyout equity in the home, right? So let's say a house equity is $200,000. I want to keep my house, but I owe now my spouse $100,000 because that's their 50% equity in the home. But I have an IRA that is worth 300,000, right? So half of that IRA would be 150, but I'm saying, oh, but I want to keep, so take your 150, but also take another 100 grand, and that would be your buyout equity. And so I take a significantly less portion, but I get it back because I'm keeping the house. That's a way to keep the house without requiring a refinance of it and just giving the other spouse a buyout option. You can have an asset, and it doesn't have to be an IRA. It could be, some people have enough in like a savings or some type of liquid cash account that they can use to award to that other spouse. If you don't have that and you're still trying to keep your house, then the other option is going to be a refinance. Like, something important for you to know though is in Texas, at least in my county, which is Montgomery County and Harris County, surrounding counties, judges are not ordering refinancing because the judge does not have the authority to make a party have to refinance property. And because of that, the only time you'll see a refinance being allowed in a divorce decree, it is because the parties mediated and it's a settlement agreement, because you can do that in mediation. But a judge cannot do that. So a judge can either decide there's enough here to give some other asset to the other spouse as buyout equity, or if there's not, order that the house be put up for sale and that the proceeds be split 50-50 or through an equitable division. Those are typically the only three options to keep the house in Texas. It just depends on what your position is, whether you want the house or don't want the house, to then know, okay, what am I going to take? What am I willing to do, to keep it or to let him have it without it being put up for sale. And in the divorce process, no matter if it's the buyout through a different asset or it's the refinancing, there's certain documents that the parties will execute. The party who's going to keep the house is going to sign a deed of trust to secure assumption, basically saying, I'm keeping the house with the mortgage subject to refinance or whatever the terms may be, or just keeping the mortgage as is, but I promise that I will pay it. And if not, here you have a lien that you can use to go back to court to foreclose because I've stopped paying the mortgage on the home. And then the party who is letting go of the home will sign what's called a special warranty deed. And that is saying, I'm giving all my interest that I have to this property to this person because now this person's going to be 100% owner. And typically, if you're going to refinance, the banks are going to require that special warranty deed showing that it was awarded in a divorce and that this person has conveyed all their interest to the property to you to be able to do the refinance for you and put the loan solely under your name. So it's very important to know that. But in divorce cases, emotions is so much high emotions that sometimes rationale is not seen and a party just wants to oppose what somebody wants. But you do have to bring your emotions into check when you're going into the divorce process, because it will just help the process move quicker. It will make your attorney's fees be less because you're putting less emotion. You have to think of it more from a financial standpoint, just depending on what position you have with regard to your home. So if you liked today's video and what I had to say, please like it and also subscribe to my channel. Bye.